30 April, March, 30. Right. I don't really get a better photo.
My friend, my lord, he better tell me the pay. He's in another court, my lord, right? After some time, after some time.
Lordship, she has already filed an affidavit yesterday, Lordship. Lordship, I pray for fixing this case after 2 weeks. In the email, Lordship, I instruct my client to challenge the notification.
It's not a big deal.
Notification wherein it says that Lordship, only they will accept the exchange exam pass from State Board of second Assam.
Then you will have to withdraw this petition.
There is a stay order according in this
All
case.
right. Mr. S.K. Das, counsel for the petition. Mr. Rao, appearing for the respondent state submits that the Bhattacharya appearing for senior government state submits that an affidavit has been filed. You have filed the affidavit
Yes, Lordship, I have filed, and it is tagged also.
and the same is available. And it is after 2 weeks. Labeling the appropriate requirement file with it. It's again after 2 weeks.
The interim order may continue.
Interim order passed early will continue. It's on 30 March. 30 March. Yes.
Pension method. The pension retirement was in the 2010 method, and a service paper was resubmitted method, page 18 method. Pension paper was resubmitted in their 2013 self method. But thereafter method, they have not yet finalized the pension method. Karbi Anglong meta method. I don't know whether my friend has served a copy to the Karbi Anglong because their name is not there in the cause list. It's a transfer subject. Anything has to move from there. No matter this is under the control of the government. Executive engineer and the third NEC.
You were working as what?
Regular master role worker method.
What is the meaning of a regular master role worker, Mr. Hall?
Yes, who are regularized, my lord. They are regular. They are master role worker. I don't know what is regular. It's master role worker who are regularized.
How do you regularize are they part of the cadre of
No.
PW service?
My lord, those a bunch of master role workers, my lord, in 2005, they were regularized, my lord. And all these posts are my lord, personal posts.
So those they were regularized as what?
Master role.
That's what I'm asking you. How can you regularize them as master role? You have to regularize them as grade 4.
My lord,
you have to regularize them in some post of the cadre.
My lord, that is what these are ex-cadre posts, my lord. They will never get promotion. These are personal posts, my lord. And my lord, these are already been dealt with, my lord. This honorable court has been many cases, my lord, has already dealt. Dilip Talukdar is one of the division bench judgment, my lord.
No, that is on personal post, etc.
Yes. So, my lord, the thing is that these are all backdoor entry, my lord.
No, we are not on that. We are only asking because the regularization is pursuant to orders passed by the government.
Yes.
So you regularize somebody in a vacant or a sanctioned post.
These are not vacant posts, my lord. These were not vacant, not sanctioned. Only for them only, my lord, these posts were created. And with them only, with the retirement or death, my lord, this it will get abolished. It was carved out by my lord, it's an exception, my lord. My lord, it's a 26th, my lord, I am yet to receive my instructions. Last occasion, my lord.
You've seen the last order?
Yes, my lord. I have written a detailed letter also to my department. Yesterday I spoke, my lord. So they said this recruiting is coming. My lord.
What is coming?
Sometime.
What is coming?
So my lord, the instruction, my lord, it has to come from the division first, my lord. One only I have.
No. Have you seen the last order? Even the records are not there and the court is unable to dispose of. Your chief engineer is to be present with the records. That's the last order.
Yes, my lord. Yes, my lord. Yes. Then I have informed. Same letter. Same thing I have.
So what does your chief engineer say?
My lord, they need some time, my lord. They are sending it.
When did you superannuate?
31st of March 2010.
Then why have you filed the writ petition in 26?
Well, his pension papers, my lord, were resubmitted in the year 2013. My lord.
Ah,
He was waiting, my lord.
for 13 years.
Yes, my lord.
My
For
lord,
13 years.
now
Yes, my lord. They, what happened, my lord, they are, my lord, rock qualified. And he been now, my lord, every time he visits, my lord,
these
payment
delay, my lord, now
settlement.
now under 205, my lord, Rule 205 and 206, my lord, a special, my lord, order has to be passed by the governor. Why? He has to give explanation why there is a delay. Delay?
Have you gone through the petition? 2013, your government has sent that letter. And you are waiting for that.
You are arguing before the court. Please reserve your
What type of
arguments for the
argument
court.
is placing, my lord?
No, you are addressing the court. If you want to go and scream at your friend, you can do it outside the court. When you are before the court, reserve your arguments for the court.
I can appreciate it. But whatever 2010, my lord, he retired. But 2013, they have resubmitted the pension proposal. After resubmitting the pension proposal, they have stopped, my lord.
Where is that resubmission?
Just 18, my lord. Now they are saying, my lord, this is my delay, my lord, I am delaying. What type of submission? याच्यामध्ये लास्ट मध्ये कोणाकडे पाच द्या टाईप ऑफ ऑर्डर.
Mr. Dhor, I think you have to apprise your department to be a little more conscious about the orders passed by the court.
Yes, my lord. I'm very much, my lord.
You are conscious, but whether you have conveyed the.
My lord will see my letter, my lord.
No, we
It's
are
a
not.
very,
We are not holding you to ransom.
Fine.
We are saying that have you been able to impress upon your clients the seriousness of the matter?
I have, my lord, the thing is that I can understand these last 2 days, all the offices are very much tied up, my lord, with so many things, my lord. That is the thing. Otherwise, usually, my lord, they stand-
Can this be a ground before the court that you are tied up with many important things? Therefore, the pensionary benefits of somebody should be
my
held
lord,
up.
the thing is that from 2013 to 26, the petitioner was sleeping.
Yeah, he is sleeping.
There
no
is
doubt.
nothing.
But,
So, my lord,
but the responsibility is on the department that once you have extracted service and it is a pensionable service,
my
then you
lord,
have
my
pay
lord,
pension.
my lord, the thing is that he has submitted. Maybe there are some queries, something like that.
So,
I don't have instruction.
that's what
From
we want to know.
2013 to my lord 2026, 13 years.
So how many years would you require to get the instruction?
No. I will get it within next 1 week. I'm telling my lord, I'm just trying to impress upon the court.
No,
My lord,
see, what your attempt to impress is misplaced because a right doesn't get extinguished because of delay alone. If you are required, if you are entitled to pension, but merely because there was a delay in approaching the authority asking for it, not extinguishes right, particularly pensionary benefits. Can't be done like that. You have to find out and explain what has happened to these pension papers. They were put up before the undersecretary as far back as 2013.
fine.
So perhaps
I will take it up to the
the pensionary issues are dealt with by the secretariat.
my lord. It will come from the division, my lord. Executive engineer will send it to the secretariat, my lord. And from there again, it will go back to no, then
Is from the department.
For
gazetted post, Lordship, it should be from the government.
No, government means which government in which department?
Commissioner, PWD.
That's right.
That is what.
Now, so far as pastoral workers,
Chief engineer of that.
No, my lord, it is not chief engineer.
these papers were put up before the
Undersecretary, my lord.
undersecretary.
Undersecretary. I need to fix the matter on the next day, otherwise personal appearance. Goldman. I will be direct.
Pensioners, pensioner superannuated on
31st of March 2010.
31st of March 2010. That's when they do. Pension papers of the pensioner submitted by the Office of the Executive EWR division before the Office of the Undersecretary Government some EWR certificate so issued by the executive in the see and the pensioner also status of Spain. Hero, then that remains. The respondents are yet to apprise the court as to whether the petitioner is apprise the court as to the entitlement, non-entitlement of the petitioner towards pension. And if entitled, then status of the pensioner pension proposals, which ought to have been known by the Accountant General. Proposal to be sent to Accountant General.
Yes, sir.
The Office of the Accountant General. Such circumstances, this court, earlier than 6, appearance of the Chief Engineer Roads PWD with contemporaneous reports for assisting the court in disposing of request made by Mr. Paul, standing counsel for the finance, that since claim the petitioner is relates to the year 2010, some further time be elapsed so that the department can pursue the matter and apprise the court as to the status of the claims. So, request made by Mr. Paul. This time, the petitioner to the respondent authorities to apprise the court as to the status of the claims of the petitioner, pension proposal. It's again 31st of March. Instructions as directed are not forthcoming. Seek to pass consequential order where so the department.
Right.
Mr. R.K. Talukdar appears for respondent 5 and it is for 7. Mr. Talukdar has counsel for the accountant to apply to court. That to the pension proposal and this recording.
Right.
Mr.
Public.
Ahmed appears for S.O. appears for the representation.
File our affidavit in course of the day, Your Lord.
March 1. I'm going to file the activity.
Who is the gentleman beside you? Please take your seat. We did not request your presence in court. You may take your seat. Your counsel is good enough. We are hearing your counsel. You may take your seat. Yes.
M. Burman.
M.
On
Burman
behalf-
appearing for MSC Gayon. And he submits that the counter affidavit will be filed today.
Lordship.
We are recording it. It will be filed today during the course of the day. Therefore, she submits that the matter be listed on some other day. Mr. Rai Soikia, the counsel submits that submissions of the counsel to the respondent and the affidavit filed in the course of the day. It's time to complete instructions and file rejoinder if so advised. When do you want it? 31st. Based on 31st. Mr. Chaudhary, for
This made a participant.
when is that matter listed?
No, they have been listed.
Is the contempt matter also on 31st? 31st.
She is covering the.
Yes. Contempt case and the writ petition be listed on 31st.
Okay. Madam, in this case, affidavit has been asked to file. Okay, we have received. File my affidavit. Next week. Certificate.
Some of the matters were fixed on a particular date.
That today, no.
Today, sir. These are the matters you said were heard.
Yes, item number 10.
But there is no reflection.
Yes.
What do you want to do?
File my affidavit.
But how can the matter be heard, item number 10, if your affidavit was not on record? Said substantial hearing without an affidavit.
No, Lordship. Earlier it was heard for. Earlier it was heard, Lordship. 3 days it was heard.
We are asking you, item
but
10, have you filed your affidavit?
Not filed.
Then?
Because of one, we have to produce one instruction. The issue is whether that means 97 your Lordship will find. There is a notification. Whether this will cover or not. Whether this holds the field or not. Item number 10, Lordship, page 97.
97 in item 10.
Yes. Only that much instruction. If it is binding, then we have a case and not binding.
Yes.
Page 97 in Lordship will find. An outer limit of 180 days is given to submit
The NCL
OBC NCL certificate from the date of the cutoff period mentioned in the advertisement. We say, Lordship, this notification is binding, even if the advertisement prescribes a particular cutoff date. The advertisement says 14/10/2024 is the cutoff date, and we say because of this notification, if we get 180 days, then we are qualified. Our certificates has to be accepted.
Prima facie appears to be binding.
Lordship.
Because this was at an earlier point in time.
Earlier point, 2017. But in the notification,
In the advertisement, this will be in the form of government orders in respect of an area not covered by rules. So this will fill up that gap.
Lordship,
Will continue to do so unless superseded.
Lordship. That instruction I bring in because Lordship in the last line, Lordship, 20C is categorically stated that the commission shall not open the cases where the final results have already been declared before 23/1/2007. Our
Yes.
contention was that it is for the recruitment process of 2017 only.
But it says before, the results which were declared before 2017, for that this will not be applicable. But after,
But recruitment for 17 could not have been declared before 23rd one. What instructions are necessary?
Lordship, that was not specifically received. That's why. Lordship.
You are seeking your instructions as to whether this has been superseded.
Yes, with any more instruction because Lordship in the order Lordship will reflect that in state of Rajasthan and Sakshiara that it has to be within the cutoff date, 14 days. So we have to take this whether this notification has been.
What is the journey?
Sakshiara versus state of Rajasthan. In Sakshiara versus state of Rajasthan, you will find in the order dated in item number 10, in order dated 13/2026, you will find the coordinate bench had rightly said that Sakshiara prima facie not applicable in view of the fact that in Sakshiara it relates to the state government notifications, and here these are central government notifications. The state government notifications, there is no such notification for the state of Rajasthan saying that an outer limit of 180 days is applicable.
2025 SSC online SC 757.
On instruction to get
Lordship.
Which that instructions are necessary.
Lordship.
When dated
OM Lordship is a notice.
notification
Dated 17/8/2007.
78,007. Whether the same was subsisting on the date of the agreement or superseded by any other sub. Again, no?
I think next week, next possible, because all the other candidates were sent for
Next week.
appointments.
19.
Lordship.
26.
26.
26.
So in item number 10, there is an interim order.
In order, wherever passed, will continue.
In item number 10.
The next day.
But
Party report, item
9, 11 and
13,
9, 11, and 13. Mr. Bora for 10.
10 and 12.
And for
Yes, Burwell and CBC for 13. And Mr. Jason for 10.
9
9 and 10.
9. Lord, in this matter, Lordship, this is the last order. I was waiting to furnish a copy of the excerpts of the remarks made against each of the petitions. I was directed to furnish a copy. There was basically an inquiry conducted by APDCL as to why the petitioners before your lordships were not allowed to sit in the examination conducted for appointment of Sahayaks. What were the grounds on which they did not meet the minimum quality? So since there were lots of petitioners who had filed petitions and joint petitions, I was directed to furnish an excerpt of the findings of the inquiry. I already furnished.
Lordship may know the about the case, Lordship. What happened, Lordship? Some recruitment process was initiated for
persons who were from outside, so they were treated as fresh candidates, and who were already serving in the department. They were termed as lordship, okay, more than 5 years in service. So they were treated as in-house people. So there was a separate process of recruitment for them. So accordingly, lordship, the office, PDCL, they issued some list, lordship, wherein they reflected the people who had been working with them. And verifying those lists, we were allowed to file applications online from that list, lordship. In their office only, we did it, lordship. They gave us the names, lordship. These are the people who have been working with us for more than 5 years. So we are providing you an opportunity to take part in the selection process. Accordingly, we did. But when lordship we did, they saw that a large number of candidates were there. So they said, no, we are not entertaining you. Why? Because there were lots of candidates and we cannot allow you to sit in the examination. Lordship, after receiving the applications, after giving them the online admit cards, lordship, lordship, the receipts they gave that had applied. Then after that, lordship, they started saying that no, you will not be allowed to appear in the examination. They had taken the fees also, lordship. The application fees was also taken from them, and they did not allow. So many candidates also appeared before this honorable court, and there were a number of cases, lordship. In some cases, the honorable court interfered and said that you allow them to appear in the examination. But these people came late, 1 day prior to the examination. So court passed some order to verify those names. Some people were allowed to appear, but their results were not declared, even though they appeared in the examination, lordship. That has been held up, and those cases are also pending. Some of the cases are pending, some are disposed of, and who had been working there for 10 years and more, they were directed to verify and give them proper treatment, lordship, because they were serving there for 10 and more years. That what they did, I do not know, lordship, but orders were passed by this honorable court to give them better treatment, lordship. And lordship, these people who are before this honorable court today, lordship, those people were not allowed to appear in the examination. So in some cases, lordship, honorable court directed that you verify and give a detailed report to this court by the affidavit. They didn't do that.
Is it because that you were not able to furnish it?
We furnished those documents, lordship. Whatever document they gave us, the officers gave us, we furnished before them. But they said, no, that level of, you have been submitting those from the outstations, lordship. Those we won't entertain. We will entertain whatever certificates we issue from the head office. And I don't know, lordship, many cases were filed before this honorable court, and the honorable court didn't enter into the merits of its candidates, lordship. So, lordship, subsequently, this question arose whether they were really working in those outstations or not, and they were directed to verify. And today they have produced a list, lordship, wherein they say, lordship, lordship may see the list, lordship, nil, experience, nil. But we have been working with them, and they allowed us to appear through their office, lordship, online applications, lordship. And today they have prepared a list just now, 1 minute before the matter reaches. 1 minute before the matter reaches, they gave me this list, and here I have seen that experience as based on record and payment records are nil. What is this, lordship? They allowed us to file applications from their own office. Now they say, no, we are not allowing you. You are not our people. On what basis they came to this, I do not know, lordship. Just now I have to check with my clients also, lordship, how many years they had worked and what are the documents they have.
Record?
My lord, in fact, very well, if your lordship.
No, because they are disputing.
Yes, in fact, if they are disputing this, your lordship, perhaps this will give rise to a fresh cause of action. Why I am saying so? An earlier petition was moved by identically placed petitioners, your lordship, before this court, and that Your Lordship is pleased to go through this order to perhaps make the position clear. So petitioners who are identically placed as the petitioners before your Lordship now, with similar prayers challenging the same select list. So there, this Honorable Court, the coordinate bench was of the opinion that if they want to challenge their qualification, that would be a fresh cause of action, then they have to challenge that individually by bringing on record their individual qualifications. Here they have filed joint petitions, all of them. Lordship may have paragraph number 11 of that order. From the said direction of this court, it is also clear that if any candidate is having any grievance related to the dictum of non-suitability on the ground of experience, etc., it will be open for him stroke her to avail his or her legal remedy in accordance with law. However, in the case in hand, such legal remedy has not been sought for in the present petition. That being the position, this court is of the view that the present petition cannot be entertained, and according to the same stance closed. However, liberty is granted to the petitioners, if so advised, to take recourse of the remedy as envisaged in the direction issued by this court under direction number 6 of the order dated 27/8/2019, passed in WPC number 264/19, permissible under. So today, your Lordship, even if your Lordship directs, I'll bring this on record. But when they have filed joint petitions and their prayer is only to challenge the provisional select list, your Lordship, can the scope of the writ petition, perhaps it may be very difficult to expand it to that extent, to permit them to challenge their qualification in these or their disqualification in these.
In this petition, the order which you have supplied, directed, permitted,
No, so what has happened, they were identically placed as these petitions. Some of them, because there were different groups of petitioners, some were allowed, some got an opportunity to sit in the examination, some did not. The Honorable Court directed us to first constitute an inquiry committee and examine the records of all such petitions. And if any of them are found eligible, then conduct a second examination for them and then publish a joint list. So that is why the first list was called the provisional select list. Now we conducted an inquiry, your Lordship. None of the petitioners were found to be qualified.
Right. Now, here the claim is that they were not even allowed to sit for the exam.
Because the direction that was passed, your Lordship, was they will only be allowed to sit for the examination if they are found to be eligible.
Where is that?
Yes. Lordship will find the directions passed in the earlier round at page number 5. It starts at paragraph number 5. A large number of petitioners with a similar grievance approached this court by filing different writ petitions, and by a common judgment dated so and so passed in different writ petitions, including that of the writ petition referred by the petitioner, this court issued the following directions. The reconstituted committee shall examine and find out the actual experience of the outsourced workers, including that of the petitioners in terms of the office order dated so and so. Those applicants who are found to be eligible as per the experience criteria in terms of the advertisement and who could not appear in the written examination, a separate written examination will be arranged for such candidates. Those who had appeared in the written examination need not appear again. The results of the written examination already conducted on so and so should not be declared now and should await completion of the separate examination of those found eligible by the committee. Thereafter, results of both the examination should be combined and a consolidated select list should be declared. The above exercise should be completed.
Yep.
So their qualifications were scrutinized by the committee. They were found to be ineligible. Now they have challenged the provisional.
What is the criteria of qualification?
Criteria was, your Lordship, that they needed to have.
Where is the advertisement?
All my notes, annexure 1 is the.
Your Lordship has WPC number 1789 of 2020 before your Lordship. There it starts at page number 15.
15.
Yes.
essential qualifications.
Yes, we are concerned with the post of Sahayak, Your Lordship, Office cum Field Assistant and Sahayak. Qualifications, Your Lordship will find at page number 16.
These petitioners before the court, they are claiming what? Sahayak.
Office cum Field Assistant and Sahayak.
Both.
Both.
So far as number one is concerned, contractual workers and any other power, working in any other power sector also. Then 5 years, 5 years. Sahayak is?
Sahayak is contractual workers under direct employment of APTCL, AECL, any other power sector for not less than a minimum period of 5 years as on so.
It is the shortfall so far as the petitioners are concerned.
The document which I have produced before Your Lordship today, that in the inquiry committee, their payment records were not available with us. Your Lordship. So that is why in the previous, in the petition filed by the identically placed petitioners, the Honorable Court had granted them the liberty to challenge it if they so feel.
Payment records are not qualification.
Because, Your Lordship, if they are claiming to be working as outsourced workers under us, Your Lordship, they'll need to substantiate it with.
Qualifications are HSLC or equivalent.
No, we are talking about the experience.
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 Experience is that if they're engaged, there must be process of engagement.
Yes, and payment, those are not available.
Payment is one issue. Who engages?
They were engaged by subdivisions.
Then
those records were not available.
Not available. Why are they not available?
Because there is no proof of that they were engaged for a continuous period for 5 years as on 1/1/2000.
What do you say, Mr.
Lordship, we had at that relevant point of time, Lordship, a list were prepared by them because we were, Lordship, applying for the in-house candidates, Lordship, those who were working, Lordship. So accordingly, Lordship, they gave us some list and we were told to take certificates from our outstations, Lordship. We did that. We placed it before them. After placing it before them, they started. There was a criteria how we should place it. Who will issue those certificates? That is also in the advertisement, Lordship. Accordingly, we submitted those documents, Lordship. But they said, no. These people, if these people give, we will not entertain. If these officers give, we will not entertain. But we were.
Who are these officers?
Lordship, that I will point out, Lordship.
So otherwise, if Your Lordship has the prayer such identically made, the challenge is only to the provisional list. They have not challenged these findings of the inquiry committee.
Lordship, in the experience category, Sahayak, Lordship,
Where?
page 16.
Yes.
Sahayak. Number 2 is Sahayak. First, number of posts, then job profile. Number of posts they didn't declare. Job profile, essential qualification, then experience. Contractual workers under direct employment of APTCL, AECCL, APGCL, and any other sector, power sector PSU engaged as Sahayak and who have rendered service for not less than a minimum period of 5 years as on 1/1/2018 on the condition that the concerned head of establishment, concerned head of establishment, controlling authority not below the rank of CEO, DGM, SE, would certify the eligibility of 5 years or 1780 days of engagement in so and so in the 7 years. Those things we have given. Those certificates issued by Lordship, these officers. See a rank of CEO,
Where are
rank of DGM,
Where?
rank of SC. Those we
Page-
have given, Lordship.
Page number? Just a sample.
Lordship, I am taking this case, Lordship. Additional affidavit lordship, page number 9 lordship.
Additional.
Additional affidavit lordship. Number 1789.
Additional affidavit or affidavit in reply?
Affidavit in reply lordship. Sorry, affidavit in reply lordship.
Yes. Page number?
Page number starting from page number 9, expense certificate lordship. And the associate and the section number 1 associate lordship issued by the subdivision engineer lordship. SEO lordship. Therefore, next one lordship, page number 10 lordship, deposit cert, page number 8 lordship, issued by the subdivision engineer lordship. And dated 9/8/2018 lordship. Is working for 5 years lordship. Number of days 1827 lordship. Next lordship, page number 11 lordship. Issued by the assistant general manager.
But they are not CEO, DGM, SE. Your certificate is to be issued by CEO, DGM, SE.
Yes, CEO, DGM, SE subdivision engineer.
SE means superintending engineer.
But they are working under this lordship, them lordship. These matters lordship, those that have come today lordship, these are second round of litigation. In the original round lordship, the first round lordship, we had placed all the documents lordship, that I have at home lordship. All those documents which we submitted in that case also lordship, those were required to be verified by them. They didn't verify those record lordship, and today they came with a list, this list lordship. Nil, as if we have not worked with them. So I can place those documents lordship.
Place it, but
Lordship. And lordship.
If we go by the advertisement,
Lordship.
the advertisement has a specification.
Lordship. I
The
understand.
certificates must be by CEO, DGMS.
Exactly.
If you have two certificates,
Lordship, we have those certificates. And lordship may say another thing lordship. Because of these irregularities lordship, their lordship, the chief general manager had issued an order which says that payment record may not be with them lordship. Still, they should have been considered.
This was considered by the company. That is why in the previous order,
Now he is saying that we do not have payment record.
I am not saying it, the inquiry committee.
Exactly, not you, not the council. Don't take it yourself.
payment records appears to have are not available in respect of field offices. They appear to be working in
This aspect of the matter was taken note of by the committee. And then after exam, along with the records of the field office, the records of the
now let us say in your chart you had given the experience based records of field. Now what documents were examined in
documents, the field office as well as the head office. I have the, for example, this is the respect of the Borbeda electrical circuit. Just one electrical circuit. But you will kindly have a look at this. The excerpts have been taken from this. Both field office as well as payment records available in the head office were examined. For each and every person who submitted his record. Should otherwise become voluminous, I was directed to just place the excerpt. If your lordship.
that.
Yes.
Now if you are saying that their documents are not available.
Yes.
Then
Then what? Perhaps an individual affidavit will have to be filing each of the matters a lot because they're filed
consolidated.
very well. I'll just this
Or district wise, whatever way you want. Why do you consolidated matter?
At 1.6 point of time,
Very
it
well.
so happened that Honorable Court directed us to place those documents before this Honorable Court. If we place those documents before this Honorable by Banse's Lordship, I think the Honorable Court has it, Lordship, this much. That may be their Lordship. I do not know, Lordship, whether those things have been disposed of or not, but we placed before this Honorable Court also. All those documents, Lordship. Use bundles, Lordship.
Let it be on record first.
Very well. I'll bring this on record.
Because see, what you are presenting before us are the rejection orders, essentially.
Yes.
We are accepting your statement that these documents were submitted by the petitioners not are not certified by CU or DGM or SC. Therefore, they will reject.
Then perhaps if I may also bring the inquiry report along with this, that will substantiate and the manner of inquiry that was undertaken. Because almost there are.
You can keep it with you, and for permission of the court, you can show
Very,
wherever required.
very well.
Because this is opposed to their claim that these certificates are available and were produced. In spite of that,
Otherwise, the inquiry report has not been challenged. Inquiry report, and that was precisely why in the other matter, Your Lordship, the repetition was dismissed. They will have to challenge, perhaps challenge this report.
but this inquiry report is not brought on record. It's brought on record.
No, not brought on record. I wanted to bring it on record. On the last occasion, the Honorable Coordinate Bench was the opinion that the excerpt should suffice.
Because it is a voluminous one.
And they have filed joint petitions across different electrical.
What do you say, Mr.
That in filed also, and we will also place those documents. Also. Those documents which they say cannot prove, we will place before the Honorable Court, and the Honorable Court,
But
one or two cases.
Assuming except some dispute,
Not so.
then some orders will have to pass in,
Not so.
pass in respect to the inquiry.
Not so.
The inquiry and the challenge.
Not it. Those inquiry report also we need to
You
send.
don't have it.
No, we don't have it.
Take to the and it will be accepted. It's required. Yeah. Specified in it. Yeah. Permitted to sit in the
Not-
exam.
Not to.
Allowed to sit. Stop the respect of the petition. Stop the right. Where is the advertisement?
Page 16.
CEO/DGM/SE. And also supporting documents regarding payments received for the service. Down. And court is of the view that the list of candidates who were found to be rejected were rejected on the ground of non-availability of experience. Same. Relating to the inquiry undertaken in respect of the requisition. This matter. Well,
After I need around 4 weeks time, you know. Not very after.
they listed after 4 weeks. It's on 21st April.
One interesting thing, Lordship. These people, so there are two categories of post, Lordship. One meter readers and one who works in on the lines, Lordship. The meter readers, Lordship, they allowed, Lordship, they give payment record because he have to sign. Meter readers are those who give us the Lordship bills. He have to sign. So his payment record is there with them. And those people who work on the lines, Lordship, during calamities also they work, Lordship, but those things are not there. Those are not on record. I don't know how many people they have, Lordship, working for them, but Lordship will not find a single record of them working, Lordship. And this thing goes on in APDC, Lordship. No document of these people, Lordship. And they always suffer. Any electrocution, they suffer, Lordship. Not the meter readers, Lordship. And the meter readers have those documents, Lordship. Payment record, because they have to sign the bills. Those are the payment records. And if Lordship verifies the people they have selected, Lordship will see every of them. Almost, Lordship, 90% are meter readers. Not those people who work on lines. Surprising thing, Lordship, how they make the payment, who these people are.
There are still
only 10% have. Some people have lots.
There are people who have sat for the examination, have produced records, and they have qualified and got through, and now they have their
10% also. I am telling them.
So these are people who do not have their qualification, and now they have coming up with excellence.
Not have the certificate, the authority using.
Lordship, they give, Lordship, they give. But payment record, Lordship, how they make the payment, they give it to one person. Suppose 5 people are working online, Lordship. They give it to the bank of one person, bank account of one person. And they say you get it distributed among yourself, 5 people. This is the process how they work.
We will examine that.
I take back the record for him.
Yes, please.
Lordship is keeping that further.
But if it comes, you have to change your affidavit.
Lordship.
After that, we decide the extent of hearing the trial.
My friend is also insisting.
Let's complete the PD and then. Yes. Yes.
chairman, certificates were issued.
For this is against for the respondents here. Still justice. Where is health department? Health department. Yes. Yes, Mr. Soik, yes.
As per advertisement, Annexure A, they applied, they applied for the post of grade 4, as they were being selected by the medical authority of Golpara. This, I have annexed the B series. They have certificates of the hearing impairment method as Annexure B series. Certificates were issued by the competent authority. Annexure B method 5 to 36, 37, 9. There is 5 petitioners. And according to my note, they applied for the post and the interview was held by the Gauhati University. And the Gauhati University, my lord, selected them. They have annexed the document, my lord. Made by the Gauhati University. This 5 months. And their names will appear at page 66. My lord, Petition number 77, petition number 5, in the Department of Animal Husbandry and Veterinary Department. That is petition number 5. Next is page 84, serial number 84. It is used for Public Works Department.
What do you
Petition
do?
number 1. What's it? Then
Health department.
page 67, serial number 116. Is petition number 4. For the Health and Family Welfare Department. Last page, next page. And serial number 116. Petition number 4, Visit Kumar. And then another page 67, serial number 36. That's petition number 3. Yes, page 59, Lord.
When was it conducted, this election?
University Mother Gauhati.
When, which year? Which year?
It was conducted by the on it was based on 31/1/2021. 2023. Directed the department wise you select them. So some person put on High Court and the High Court directed the Gauhati University that is select them department wise. We have managed that order. Right, my lord, it will make clear. 65. Candidates has prepared in persons of the judgment of order dated 21-1 and dated 9-1-23 in early number so and so. Candidates for that is for fidelity. Then the department was all the departments are mentioned of the bloodshed. And then department wise my lord at page 66 that I have shown you bloodshed. We have been selected and for particular those departments. Now, when these certificates are issued, the annexure F series is 41 bloodshed was issued as per the unique disabled persons government of India at page 47 annexure F series. That is, the certificates are they have never cancelled it. Only the thing is that again by issuing this notification, they called us to appear before another to the Gauhati Medical College. Now, what's it? While the out of 513 candidates, 360 have been already appointed.
I think there is a similar matter judgment by a court and bench where it was held that there is nothing wrong for subjecting candidates to second examination. And perhaps this matter is under appeal. That is why the health council is discussing. Where is the health council?
They did not file the affidavit also. They were directed to file the affidavit.
Wait for some time, let the health council for health department come. Yes. Yes.
So Mr. Pathak is on board. As per last order, we were supposed to file the relevant charge regarding the pay metrics. We have prepared the same. The same may be allowed us to pay by way of evidence.
You have already been allowed. File an affidavit.
Yes.
Bring it on record. Council for the petition is permitted to bring on record by way of an affidavit the charge. Fair. Yes.
In this, there were 3 limbs of prayer, 2 limbs of prayer, my lord. One, I challenge the disciplinary proceeding itself, the manner in which the disciplinary proceeding was conducted and the inquiry report was filed. Your lordship, at that stage, after filing of the inquiry report, stating. So far as the second limb of argument, prayer was there, my lord, that was not restating me for without any review. That prayer has become infectious because meanwhile I retired and your lordship directed to give provisional pension, which I am getting. Now, why my lord the disciplinary proceeding is challenged? Because yes, lordship may have a look at the charge sheet, charge on the which whether this charge can be by itself can amount to misconduct or it can form the very foundation for initiation of disciplinary proceeding as page 40. Page 40. Like when the letter came last time, let me have a look at my last order dated 5/1/26. Government also on this. Dated 5/1/26.
Yes, page 40.
Page 40 is the minor show cause notice. Charge number 1. Charge is incorporated here. That while you were holding post of so and so, you were arrested by the crime branch in connection with so and so. Such conduct on your part, government tarnish the image, you are therefore charged with misconduct. So the question before your lordship's adjudication will be whether arrest by itself can form a foundation for a disciplinary process. Now, kindly the next page, my lord, 41. See the statement of allegation. Statement of allegation is that on so and so date, you so and so was arrested by crime branch. Then kindly see the list of documents, WT message by DCP, Deputy Commissioner. These two documents were all about my arrest. All about my arrest. Only one witness, officer in charge of the crime branch. Then, my lord, also about the manner also, lordship may have a look at page 61 and 62. Manner in which the inquiry was conducted and report was furnished. Lordship may kindly turn to page 61. Statement of middle, 6.2. Only two witnesses. One was the initial officer in charge. On his transfer, my lord, the second one came. IO. PWD1 said that so and so was arrested and forwarded to judicial custody. That's fine. Then number 2,
Tell us that you are challenging the proceedings.
proceedings.
What is the ground for challenge of the proceedings?
That the allegation or charge that you were arrested, that constitutes misconduct. And arrest by itself cannot constitute the foundation for initiation of the
What does the conduct rule say?
conduct rule, my lord. 1964 rules.
No. Conduct rules.
Yes. Inquiry authority shall in the course of inquiry, I am reading, my lord, in any other inquiry also. Rule 6, Rule 8, disciplinary authority, 9, procedure for imposing penalties. Suspension is there. Suspension is all right. Once I am arrested for 48 hours behind the bar, automatic suspension. No question. And other limit was whether a parallel proceeding, and there are Supreme Court decisions which I shown to your lordship, because of which your lordship granted the stay of the inquiry, that advisable when the trial is going on, don't go for it. They have not gone for it. Arrest. Then, my lord, procedure imposing penalties. Sub-rule 6, inquiry authority shall in course of inquiry consider documentary evidence, oral evidence, as may be relevant material in regard to the charges. Government servant shall be entitled to cross-examine witness presenting the case. So these are the, my lord, the procedures all flouted. All flouted. Come back to page 61 again.
Yes.
Page 61. See below 6.2. One Sri Narjari, who was the investigating officer, he said, "It is, my lord, in verbatim the charge sheet. Narration of the charge sheet in the trial. This was read over. This was recorded by the inquiry officer." And next page 6.3. No material produced, not even Xerox copy, no evidence adduced, no witness examined.
What is the stage of the criminal proceeding?
My lord, that is the evidence. Trial.
Stage of evidence.
Trial is going on. Already 3 witnesses examined. And here, my lord, PW2 states that after visiting so-and-so, IO of the criminal case, my lord, and the findings are that based on the materials on record, findings are as follows: misconduct is proved. This is the inquiry report. In the most perfunctory manner, my lord, I was not allowed to cross-examine even this IO. No material, neither the informant, complainant was well. Parallel to a criminal trial, you can still hold. Law is that, man. Can still hold a disciplinary proceeding, but that will have to be a disciplinary proceeding where all opportunities have to be given. Dependent of the trial, you will have to prove. If opportunity of hearing, materials produced, the document will have to be, my lord, testified to by the witnesses. No witnesses, only the IO can. By the time, my lord, the charge sheet that is reproduced and the finding is given. So this is my humble submission. As well as this inquiry report is liable.
Now the question is, now the question is
Not
that the interim order passed, there was no final order issued in the inquiry, right?
at that stage, you will also stay.
Right.
It's inquiry. It's inquiry.
The
I
inquiry,
challenge this.
therefore the inquiry has concluded as on date.
The inquiry has concluded. The report is come. This is the findings of the inquiry. Subsequent stage has not come.
Where is the finding of the inquiry?
This is the page 61 and 62 below findings.
61 and 60.
Page 62 below 8.
Now, this will have to be decided or accepted or by the disciplinary authority.
Disciplinary authority, my lord.
Disciplinary authority.
They will dismiss me tomorrow on the basis of this.
The
for this stay or
disciplinary authority
I will not
may
get
not
the
accept it.
sanction.
May not accept it. That may differ.
But at this stage, my lord, the very foundation I am challenging. Whether can it be called a disciplinary proceeding in the IF?
Where are the records of the proceedings? Disciplinary proceedings?
I have been told the records, once it came, again, we have returned it. We have to place this record.
Let us see how you conducted the disciplinary proceeding.
But for your stay order, my lord, lordship stay order, on the report date, tomorrow they will dismiss me. And I'll forgo even the provisional pension. Suppose what if I am acquitted in the trial? If I am convicted in the trial, I am out of this court. I go from service. What if I am acquitted?
If you are acquitted, then your
That's
claim
right.
will be decided again.
That's right. That's right. So we cannot condemn a person by not, whether it is a criminal trial, whether it is a disciplinary proceeding, without, my lord, in accordance with law, we cannot condemn.
Mr. Gogoi, you
May I
show us the
request?
records.
My lord.
Show us the records. Third, Mr.
Appeal, my lord.
Borbora.
Thank
The
you very much.
counsel assisted by Mr. M. Smith. The Excise Department. The petitioner challenged the disciplinary proceeding.
As well as the inquiry order.
As well
Inquiry
as the
report.
Inquiry report. So, primary challenge. The inquiry proceeded in the manner of procedure prescribed under the so 1964. Some discipline appeal rules 1964.
The charges arrested.
Submitted that the only charge leveled against the petition charge of being arrested. Action with the- And subsequently, of course, the petitioner was enlarged on bail. The departmental proceedings have been initiated, and petitioner was not given an opportunity to examine the witnesses, including the IU. And as a consequence thereof, the inquiry is to stand vitiated, as it is contrary to the prescribed law.
But from I have no witness, not even the complainant.
Complainant was not there. No. The complainant, the matter, basis of the statement of the IU, that the inquiry officer charges against that state. The petitioner came before this time and spoke by way of entry order.
My lord. 15/5/2024.
by order dated 15/5/2020. Meanwhile, petitioner respondents, you have filed your affidavit?
Affidavit has been filed.
They have
Filed your affidavit.
They have not denied that witnesses were.
However, considering the fact that challenge proceeding was initiated in terms standing counsel for excise, Mr. D. Uwe, will place the relevant records pertaining to the disciplinary proceedings
9th of April.
initiated against the writ petitioner. On the hearing on 9th of April.
9th of April. Lordship has been extending the interim.
Yeah, how long would you require?
Let us post it after petition. Because 9th April,
All right.
10th April, these will be motion days.
Oh, all right, my lord. All right, I have already retired getting provisional pension. Protected by your lordship.
21st of April.
21st,
Sorry.
21st.
23rd of April.
23rd of April.
23rd.
Interim self-control.
Yes. Order passed early. 23rd. Next day.
All right. Interim order was extended, my lord, 3-4 days, my lord. Let it be under order. Sometimes matter doesn't reach.
If it doesn't reach, you apprise the court. The court also desires the appearance of counsels on every date, at least to extend the interim.
I am already.
Otherwise, if it is extended until further orders, we may not have the pleasure of your presence here.
I am always here with my ugly face. Doesn't matter.
Yes.
But other than my learned friend said regarding a jurisdiction or maintainability of the case. So, my lord, I have brought some citations. I think one would be not even lordship.
Why,
is satisfied.
what is the jurisdiction issue?
Yes, lordship may.
Dismissal order was passed in UP by
He is a resident of
President of
Tirang, Tirang, Assam.
I mean, Assam.
Now, lordship, kindly see, para 8, it was stated by the Honorable High Courts that High Court has no jurisdiction if the occurrence took place in one place. But the Honorable Supreme Court has given the explanations, details of the judgment and has not accepted the reasonings of the Honorable High Court.
Please
Can-
read it. Please read it. Para
Yes.
8.
Para 8. While interpreting the aforesaid provision, the Constitution bench of this court in Election Commission versus Shaka Venkata Rao held that the writ court would not run beyond the territory subject to its jurisdiction and that the person or the authority affected by the writ must be amenable to court's jurisdiction jurisdiction either by residence or location within those territories. The rule that cause of action attracts jurisdiction in suit is based on statutory enactment and cannot apply to writs issued under Article 226 of the Constitution, which makes no reference to any cause of action or where arises but insists on the presence of the person or authority within territories in relation to which the High Court exercises jurisdiction. In another Constitution bench judgment of this court, in K.S. Rashid and Shan versus Income Tax Investigation Commission, this court took the similar view and held that the writ court cannot exercise its power under Article 226 beyond its territorial jurisdiction. The court was of the view that the exercise of power conferred by Article 226 was subject to a twofold limitation. That is, firstly, the power is to be exercised in relation to which it exercises jurisdiction, and secondly, the person or authority on whom the High Court is empowered to issue writ must be within those territories. These two constitutional bench judgments came for consideration before the larger bench of 7 judges of this court in Lieutenant Colonel Khazur Singh versus Union of India. The bench approved the aforesaid two constitutional bench judgments and opined that unless there are clear and compelling reasons which cannot be denied, this court cannot exercise jurisdiction under Article 226 of the Constitution beyond its territorial jurisdiction. Here, the Honorable Supreme Court gives the explanation. 9. The interpretation given by this court in the aforesaid decisions resulted in undue hardship and inconvenience to the citizens to invoke this jurisdiction. As a result, Clause 1A was inserted in Article 226 by the Constitution 15th Amendment Act 1963 and subsequently renumbered as Clause 2 of the Constitution 42nd Amendment Act 1970. The amended Clause 2 now reads as under: power of High Courts to issue certain writs. Notwithstanding anything in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including the inappropriate cases, any government within those territories, directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for the enforcement of any of the rights conferred by Part 3 and for any other purpose. Then Lordship can see next time on a plain reading of the amended provision of in Clause 2, it is clear that now the High Court can issue a writ when the person or authority against whom the writ is issued is located outside its territorial jurisdiction if the cause of action wholly or partially arises within the court's territorial jurisdiction. Cause of action for the purpose of Article 226(2) of the Constitution for all intent and purpose must be assigned the meaning as envisaged under Section 20C of the Code of Civil Procedure. The expression cause of action has not been defined either in the Code of Civil Procedure or Constitution. Cause of action is a bundle of facts which is necessary for the plaintiff to prove in the suit before he can succeed. The term cause of action as appearing in Clause 2 came up for consideration time and again before this court. Here, then Lordship would kindly go to para 11. This provision was again considered by this court in Oil and Natural Gas Commission versus Utpal Kumar Bosu. In this case, the petitioner Oil and Natural Gas Commission, ONGC, through its consultant engineer India Limited, issued an advertisement in the newspaper inviting tenders for setting up of kerosene recovery processing unit in Gujarat, mentioning that the tenders containing offers were to be communicated to EIL, New Delhi. After the final decision was taken by the steering committee at New Delhi, the respondent so moved the Kolkata High Court, praying that ONGC be restrained from awarding the contract to any other party. It was pleaded in the petition that NICO came to know of the tender from the publication in the Times of India within the jurisdiction of the Kolkata High Court. This court, by setting aside the order passed by the Kolkata High Court, came to the following conclusion. Therefore, in determining the objection of lack of jurisdiction, the court must take all the facts pleaded in the support of the cause of action into consideration, albeit without embarking upon an inquiry as to correctness or otherwise of the said facts. In other words, the question whether a High Court has treated jurisdiction to entertain a writ petition must be answered on the basis of averments made in the petition, the truth or otherwise, whereof being immaterial. To put it differently, the question of jurisdiction must be decided on the facts pleaded in the petition. Therefore, the question whether, in the instant case, the Kolkata High Court had jurisdiction to entertain and decide the writ petition in question, even on facts, else, must depend upon whether the averments made in para 5, 7, 18, 22, 26, and 43 are sufficient in law to establish that a part of cause of action, this is very important, a part of cause of action had arisen within the jurisdiction of Kolkata High Court. Then Lordship may kindly come to page para 19 and 20. 19, para 19. Considering the entire facts of the case narrated herein before, including the interim order passed by the High Court, in our considered opinion, the writ petition ought not to have been dismissed for want of territorial jurisdiction. As noticed above, at the time when the writ petition was heard for the purpose of grant of interim relief, the respondents, instead of raising any objection with regard to the territorial jurisdiction, opposed the prayer on the ground that the appellant writ petitioner was offered an amount of rupees so, but he refused to accept the same and challenged the order granting severance compensation by filing the writ petition. The impugn order therefore cannot be sustained in the peculiar facts and circumstances of the case. In the aforesaid, the appeal is allowed and the impugn order passed by the High Court is set aside and the matter is remitted to the High Court for deciding the writ petition on merits. Here is the case, my lord. I have passed SSLC examination from Board of Secondary Education, Assam. And it was in the board's record that my date of birth is 1985. But when I filled up my form,
Now we are on the question of maintainability.
yes, that's why, madam. That is the, because it has some relevance. Now they sought a report from the Board of Secondary Education, Assam. The Board of Secondary Assam sent a report to the authority in Lucknow that actually his date of birth is 1984, not 85. So, on the basis of that report, I was dismissed from my service. That when I did not reach the age, when I should have get the job, 1 year I have increased to get the job. So that was their motto and they have dismissed me. So I have appeared in my examination in Assam. My house is at Sirang district in Assam and report has been called from Lucknow to Assam, Seva, and Seva has sent report to Lucknow and Lucknow on the basis of the report of Seva has dismissed me from service. So part of the transactions, unknown of facts, several things have happened within Assam, within the territory of this Honorable High Court. So,
Have you challenged the fine Seva?
no, I have not challenged. Actually, my lord, on the basis of which I have been charged, that is 11. That is 11, section 11 of CRPF Act 1949. Now, my lord, in
CRP.
CRPF Act,
Section 11.
section 11. Now, Lordship would say, the commandant or any other authority or office, as may be prescribed, may, subject to any rules made under this Act, award in lieu of or in addition to suspension or dismissal any one or more of the following punishments to any member of the force whom he considers to be guilty of disobedience, neglect of duty, or remissions in the discharge of any duty or of other misconduct in his capacity as a member of the force. Reduction in rank. B. Fine of any amount not exceeding 1 month's pay and allowances. C. Confinement to quarters, lines, or camp for a term not exceeding 1 month. D. Confinement in the quarter guard for not more than 28 days with or without punishment, jail or extra guard, fatigue or other duty. E. Removal from any office of distinction or special emolument in the force. Now my submission is this, my lord. Here are 5 types of punishments are incorporated in this section. I have been given the highest penalty of dismissal from service. So I have filed this case, and everything Lordship would see, even in their position, in their charges, article of charges. So our prayer was that the removal of service on the basis of the report of Seva was an excessive type of punishment. What offense I have done, I have been given more punishment. So our prayer is that should be set aside. And secondly, as to why other punishment, can you see para 11 of my read picture? Bottom.
What is the punishment imposed on you? Dismissal.
Dismissal.
Where is that order?
Yes, that Lordship may kindly say. 40, page 40. Here's the order. Here Lordship would see. Here is also
40 is the appellate order.
that has been kept as before. I filed a yes, 40, that is the order, madam. Inquiry. First was the order inquiry, submission of report, page 31, and impugned or rejection order, page 40. Here, Lordship would see one thing. I am again.
Why do you say this is under section 11? Departmental inquiry is under section.
Check. Read with 27.
Yes, page 40 can you see? The departmental inquiry under section 11 of CRPF Act 1949. There is rule 27. Now, rule 27, what does it say, my lord? That I have not read. That we say, here procedure for the award of punishments. Rule 27. The punishment shown as items 1 to 11 in column number 2 of the table below may be inflicted or non-gazetted officers and men of the various ranks shown in each of the heading of column 3 to 6 by the authorities named below such heading under the Constitution mentioned in column 7. So, my lord, regarding procedure of punishment, I have little to say, but my only prayer is this, my lord. When I was charged under section 11 of CRPF Act 1949, and there are 5 types of punishment. The highest punishment was dismissal from service. And at that time, my lord, I was below. If they are
Where is the punishment specified in section 11? It says minor punishment. Section 11 is minor punishment.
minor punishment, it is minor punishment, but last lordship may kindly see E, 11E, removal from any office of distinction or special emolument in the force. Actually,
That
I
is
think
that is
I
not
do not
removal
fall
from
within that
service.
category. My submission was that why not first thing set aside the order or some lesser types of punishment, because I have served the courts. I have also got some awards. So my service, I was appointed on 2/7/2004 and discharged on 19/12/23. That is after 17 years of service. Live, I have been dismissed from service. I have got the dismissal from service means I have been deprived from all benefits. So, removal dismissal same. Not a lesser type of punishment or some benefits.
Where is the show cause?
So plus.
Did you file
Page 18.
Did you file an appeal against this
Yes.
order?
Yes,
Yes.
the appeal was fine.
What happened?
That was rejected.
Where is the show cause?
Show cause, my lord, that is page 18.
Page 18 is the
Article of charges.
Page 18 is the order
Disciplinary-
passed by the disciplinary authority.
Disciplinary authority. And this is the letter I was given. This is the letter I was given annexing the inquiry report. That is page 21. Here I have given the relevant portion of translated copy. Page 22 bottom. Page 22 bottom. Therefore, on the basis of written oral statements presented by the plaintiff and procedural witnesses during the departmental inquiry, evidence and document provided, and the re-verification report, the charges leveled under article number 01 against the accused post number so-and-so Urunjay Basumatari, constable number so-and-so have been found to be proved beyond doubt. So this report was also annexed, and the one report is page 24 onwards.
Yes. Territorial jurisdiction. In view of the judgment, what do we have to say?
These are not applicable lawsuit, there is a full-time judgment lawsuit. There are two things, lordship, cause of action and right of action. Cause of action, lordship, here cause of action is from UP, lordship, right? Paragraph, my lordship, in Kerala, from paragraph 19. paragraph 19. May I read, Lordship? What really arises for the decision is whether the fact that on communication of the order it became effective as far as a person is concerned and gives him a right to approach the court for relief is really a fact which is a part of the bundle of facts that constitute a cause of action.
What you have to refer to the judgment and also the judgments rendered by the apex court.
Okay.
Findings of the apex court are binding.
Gotcha.
So, distinguish by reference to other judgments. Okay?
Yes. Yes. Sir.
Paragraph
Lordship, from that's why I'm reading from paragraph 19, Lordship.
19.
Lordship.
One more. See, assuming courts. 19.
What really arises from the decision
Yes.
what really arises for the decision is it is referred to the full bench. That's right.
Huh? Bench of?
Kerala,
You are referring from which? You are reading which judgment?
2014 SSC online Kerala.
Ah,
Kerala
19.
19.
yes.
What really arises? When really arises for the decision is whether the fact that on communication of the order it becomes effective as far as person is concerned and gives him the right to approach the court for relief is really a fact which a part of bundle of facts that constitute a cause of action. It is well recognized that there is a distinction between cause of action and right of action. In American Jurisprudence, second edition, volume 1, although the court sometimes confuses the term cause of action, the right of action, and state that right of action, the law arises from the existence of a primary right in the plaintiff and the invasion of that right by some illicit on the part of the defendant. In a legal sense, these terms are not synonymous or interchangeable. A right of action is the right to presently enforce a cause of action. A remedial right affording redress for the infringement of legal right belonging to some definite person. A cause of action is an operative fact which give rise to such right of action. Right of action does not arise until the performance of condition precedent to the action and may be taken away by running of the statute of limitation, though and estoppel, or by other circumstances which do not affect the cause of action. There may be several rights of action and one cause of action, and rights may be acquired at different times from the same causes. The above distinction has
been conflict with the Supreme Court judgment.
Lordship. Thereafter, Lordship, the discussion which my learned senior has also referred has also been discussed here. Because their cause of action, in our case, Lordship, cause of action arose in UP, Lordship.
You're right.
Lordship.
Cause of action, or a part of the cause of action.
Here, Lordship, no part of cause of action is there.
Where was the person when the order was passed? There. Where was the person?
At UP.
That
He is serving there, Lordship, not in the state of Assam. That's why,
So,
Lordship.
according to you, the only ground which he has filed this petition is that he is a person of this.
Yes. And the inquiry, Lordship is saying that both second he has studied here, and the references report is called from here. And in the petition regarding territorial jurisdiction, nothing has been written that this court has been written.
But that is pursuant to an objective reason.
That this court has jurisdiction, he has also not said.
Of course, is it necessary to be pleaded under the High Court rules?
No. But Lordship,
you are entitled to raise an objection.
Lordship. May I read, Lordship?
Yes, yes.
The above distinction has been referred to by a full bench of the Allahabad High Court in Balbir Singh versus so. Their lordship held that the term cause of action and right of action are not synonymous and interchangeable. Right or action is the right to presently enforce a cause of action, a remedial right, affording redress for the infringement of legal right belonging to some definite person. A cause of action is to be operative facts which give rises to such right of action. His lordship, Justice so adopted the same approach and noticed the distinction between the cause of action and right of action in so. A division bench of Allahabad High Court held that a right of action is to be right to enforce a cause of action. A person residing elsewhere in the country being aggrieved by an order of the government, central or state, or authority or a person may have the right of action at the law, but can be enforced or the jurisdiction under Article 26 can be invoked of that High Court only within whose territorial limit the cause of action wholly or in part arises. Cause of action arises by action of the government or authority and not by the residence of a person aggrieved. That, but yes. In a case where an officer in the Indian Air Force was superseded when he was posted at Madras, and he sought to a direction by filing a writ petition in the High Court of Allahabad to command the appointing authority to decide a representation made by him. It was held that the High Court at Allahabad had no jurisdiction since no cause of action arose within the jurisdiction of the High Court at Allahabad, which would entitle that officer to approach the High Court at Allahabad, and the direction was sought to the authority whose office was situated in New Delhi. In following this decision and referring to earlier decision on the subject, another division bench of Allahabad High Court in so held that illegality in the award of contract at a station outside the jurisdiction of the High Court of Allahabad could not be entertained in the High Court of Allahabad merely on the ground that the station where the contract was to be performed fell within the jurisdiction of the High Court of Allahabad. In recent decision of Supreme Court, the Supreme Court held that where a case was registered at Bombay, a wireless message issued to the respondent at Itanagar, Arunachal Pradesh to come and to see the inspector CBI at Bombay on its receipt that Itanagar does not confer jurisdiction of the High Court at Gauhati under Article 26 of the Constitution was the first FIR. The court took the view that the receipt of information by aggrieved person that he should meet the concerned inspector at Bombay does not enable that the person to approach the High Court, which has jurisdiction over the place from where he received the communication. It appears to us that the decision of swastik property case and the decision of the Supreme Court, that of the High Court subsequently, there to clearly establish that the receipt of communication by itself does not constitute a fact in a bundle of facts constituting the cause of action. At best, receipt of the order or communication only gives the party a right of action based on the cause of action arising out of the action complained of. When that action complaint takes place outside the territorial jurisdiction of the High Court and an appeal therefore be dismissed by an authority located outside the jurisdiction of the High Court, cause of action only arise outside the jurisdiction of the High Court and Article 6 of the Constitution cannot be invoked to sustain a writ petition in this High Court on the basis that the part of the cause of action that has arisen within the jurisdiction of this court, merely because the appellant order communicated from the seat of the appellate authority was received while the petitioner was residing or working within the jurisdiction of this court. Acceptance of the argument that the status of the receipt of the order will determine the jurisdiction can lead to a position where a litigant would be in a position to choose his own court for the purpose of redressal of his grievances. All that he needs to do is move over a particular place for receiving the communication from the appellate authority and then approach the High Court of that place with the plea that the court has jurisdiction before, because the order of the appellate authority has served on him while he was residing within the jurisdiction of that High Court. No litigant can have a right to choose the court for seeking relief, and mere introduction of clause 2 of the Article 26 does not alter that position. It is now settled settled after the decision of the Supreme Court in Successor versus so and so, that when there is an appeal against the original order, even in the service dispute, there is a merger of original order in the appellate order, and the decision rendered by the appellate authority, whether it is to be dismissal, reduction, allowance, or modification of the order of the original authority, a cause of action accrues the aggrieved person to challenge the appellate order, since the order was original authority merged in the order of the appellate authority. What furnishes the cause of action is the rejection of the appeal by the appellate authority. Communication of that order, though the order became effective only on such communication to the aggrieved person, only furnishes the aggrieved person with a right of action. Receipt of communication is not a fact in the bundle of facts constituting the cause of action. Even though only on receipt of the order aggrieved person may be able to challenge that order, receipt of the order cannot be said to be a fact forming the cause of action. For the cause of action arising on the appeal being dismissed by the authority outside the jurisdiction of the court, the fact that until an order is published or made known, the order does not become effective, since it will be open to the authority to change his mind before releasing the order, is not a ground to hold that the communication of the order has also been formed a part of cause of action to a aggrieved person. The fact that the person who was dismissed from service while he was in service outside the state would have to suffer the consequences of that dismissal when he is in his native place by being rendered jobless is not a fact which constitutes the bundle of facts giving rise to the cause of action in his favor to challenge his dismissal. That right him earlier when he was dismissed from service outside the state and he lost his employment. Similarly, when an appeal is filed by him to an appellate authority outside the jurisdiction of this High Court, an appeal is dismissed by the appellate authority. The merger in the decision of the appellate authority takes the place when the appeal is dismissed and not when the appellate receives the order. What a rate petitioner need pleaded as a part of cause of action is the fact that his appeal has been dismissed or in part, and not the fact that the order was communicated to him. That he is relevant only to show when the right of action arose in his favor. The receipt of order only gives him a right of action on already accrued cause of action and enables him to meet the plea of latches or limitation raised in the opposition. That the consequence of this proceeding in larger sense are suffered by a person in his native place is not a ground to hold that the High Court within the jurisdiction of the native place is situated is also competent to entertain a writ petition under Article 6 of the Constitution. When a person is dismissed or reduced in rank, he suffers the consequences where he was employed at the relevant time and not in his native place to which he might have retired or dismissed. And last paragraph 22. In the case before us, consequences of the order of the original authority were suffered by the respective petitioner outside the state. One was dismissed and other was reduced in rank. Therefore, thereafter they filed appeals before the appellate authority whose officers are in Delhi. One of the petitioners came with in Trivandrum on his losing the job, and from there he received the copy of the order dismissing his appeal. After suffering a reduction in rank from outside the state, the petitioner had obtained a transfer to state within the jurisdiction of this court. He had also suffered the punishment while he was outside the territory of the High Court, merely because he was working in Kerala at that time when he received the copy of the appellate order dismissing his appeal. Cannot be said to be a part of cause of action to challenge the appellate order. In both these cases, therefore, we have no hesitation to hold, including that no part of the cause of action arisen within the jurisdiction. The objection raised is that we have by the respondent was found. After looking this reputation. Following this, I've given another Air lordship order was blacklisting order was communicated from Mumbai. Appeal. Here, Lordship, Khajur Singh is also discussed here, Lordship. Para 41.
What about this Nawal Kishore?
Nawal Kishore was
Considered anyway.
put by my senior.
That you discussed.
Lordship, in Nawal Kishore paragraph 11, this provisional of Calcutta High Court changes EAL.
Nawal Kishore and the-
Cause of action. Cause of action.
wants to be on submission.
Considering the entire, in paragraph 19, it says, considering the entire facts of the case narrated herein above, including the interim order passed by this High Court, in our considered opinion, the writ petition ought not to be have been dismissed for want of sensible as noticed above. At the time when the writ petition was heard for the purpose of grant of interim relief, the respondent, instead of raising any objection with regard to the territorial jurisdiction, opposed the prayer on the ground that the appellant writ petition was offered an amount of rupees so and so, but he refused to accept the same and challenges the order granting severance compensation by the filing this writ petition. The facts are also different, Lordship. Here, the interim order was also passed. That's why, Lordship, it says, considering the entire facts, and the interim order therefore cannot be sustained in the peculiar facts and circumstances. Here also says the cause of action, Lordship, paragraph 11.
The analysis in Nawal Kishore that post the amendment available for you to file.
Fine.
If part of the cause of
Cause
action.
of action. Here,
In the full bench judgment of Kerala High Court, there is another new concept that is
right of action.
huh?
Right of action.
No. Right of action, cause of action, all right. Essential cause of action. What is essential cause of action? Disciplinary authority.
Yes, 18. 40% base 20. Institution. The larger bench judgment of the honorable.
No.
And the
The law is clear. Except to address it as a part of constitution. Are you challenging the
At first, I was appointed at Gauhati. CRPF from Gauhati, I was appointed. And this era,
No. What is cause of action is to be understood in terms of the challenge made before the court. Challenge before the court.
bundle of facts that
It's
that
a
is the
challenge.
words.
It's a challenge before the court.
Challenge before is basically the order of dismissal.
Dismissal. At the time of dismissal, where were you?
At that time, I was in Lucknow.
Lucknow.
In Lucknow. But
Enquiry was conducted where? Where was the enquiry conducted?
inquiry conducted.
Departmental proceedings?
First thing, my lord, when the proceeding started against me at that time, sometimes I used to hear and I went there. In that manner, you were coming. But now I am no longer in job. Practically also, my lord, a person who has been retrenched from his job, it is not possible for him to go there. Of course, that is not the law. But law is this, my lord. Kindly see the larger than that I have given. The Supreme Court's order, what my lord had first stated that the order of the Honorable Supreme Court cannot be forsaken by any court within the territory of India, including the High Court, both in letter and in spirit. High Court has to follow the order of the Supreme Court. Now, that novel, that is Nawal Kishore Sharma's case I have given. Now I have given another case, that is Patel Roadways. Can you see?
Yes.
It is my lord. The judges are S. Ranganathan, M. Fatima Bibi, N. D. Ojha. Citation 1991, 4 SCC 270. Now, Lordship kindly see this is larger bench judgment, and Lordship would kindly see what the Honorable Supreme Court held. Para 10 kindly see. Here we may point out that the view which we take finds support from the circumstance which in our opinion is relevant. Section 20 of the Code, before its amendment by the Code of Civil Procedure Amendment Act 1976, and this has been this is also stated in Nawal Kishore's case, had two explanations being explanations 1 and 2. By the Amendment Act, explanation 1 was omitted and explanation 2 was renumbered as the present explanation. Explanation 1 2 so omitted, read as hereunder. Where a person, explanation 1, where a person has a permanent dwelling at one place and also temporary residence at another place, he shall be deemed to reside at both the places in respect of any cause of action arising at the place where he has such temporary residence. So if your lordship kindly consider this, my temporary residence may be treated, if my learned friend's argument is taken for acceptance, then my temporary residence would be at Lucknow, but permanent residence is Chirang. That is there. Secondly, this kindly says now, this explanation deals with the case of a place of residence of the defendant and provided with regard to the person having a permanent dwelling at one place and also temporary at another place, that such person shall be deemed to reside at both the places in respect of any cause of action arising at the place where he has such temporary residence. The language used in explanation 2 on the other hand, which is the present explanation, was entirely different. Had the intention been that if a corporation had its principal office at one place and a subordinate office at another place, and cause of action arose at place where it had his subordinate office, it shall be deemed to be carrying on business at both places. The language used in explanation 2 would have been identical to that of explanation 1, which was dealing with a case of a person having a permanent dwelling at one place and also temporary residence at another place. The marked difference in the language of the two explanations clearly supports the view which we have taken with regard to the interpretation of the present explanation to section 20 of the code, which was explanation 2 earlier as indicated above. Now, para 12, kindly see last 10 lines. That same page, para 12 last from the linking together.
Yes.
The linking together of the place where the cause of action arises with the place where a subordinate office is located clearly shows that the intention of the legislature was that in the case of corporation, for the purposes of clause A, the location of the subordinate office within the local limits of which a cause of action arises is to be the relevant place for filing of a suit and not the principal place of business. So that is not the split of the, that is the principle of law laid down. I am on ratio. That it is not the principal of which case has to be filed. It may be also filed at subordinate place. If the intention was that the location of the sole or principal office as the location of the subordinate office within the limits of which a case because of action arises are to be deemed to be places where the corporation is deemed to be carrying on business, the distinctive or will not be there.
See, you are telling me fasting employee
At that time,
order was served, received wherever it may have been received, but in relation to
but the original occurrence took place at Gauhati.
Huh?
My Lord may kindly have a consideration that original difficulty arose at Gauhati.
what difficulty?
Difficulty that means regarding my mark sheet, my S, that was recorded in my admit card as 85, but I use as 84.
But it was not because challenging that.
I am not on. But section 11 also gives some sorts of punishment. The highest categories of punishments have been given, actually, which is not.
These are on merit.
Yes.
We are
That's true. But the thing is this on the point of jurisdiction or maintainability,
so insofar as termination is concerned,
I think because a person may have more than one residence.
have one or two residents, that is in section 20. May be filed where the defendant resides. But on the aspect of where a cause of action or a part thereof arises. Part of the cause of action is here. Which is that part of cause of action?
Asking report from here,
Huh?
asking report from here at Gauhati, then
But that report is not undertaken.
report
by
is
you.
not understood because
Proceeding challenging that report.
my contention was that I have been given more punishment than necessary.
That is the merit.
That is one merit. So, on the this point has been raised by my learned friend. So, the judgments which I have in Naval Kishore's case, as well in this case, the ratio of the case is that if any of the places of occurrences have taken in a particular place. Maybe here and there, maybe I am not trusting on merit.
Not any action part thereof. Course of action will give basis on which the questioning a particular action or inaction. This supporting part relating to this particular challenge has risen involved. Same. Yeah. But the proceeding, you are not challenging that.
No, I am not challenging.
Challenging.
I have only filed the writ
You
petition,
are only challenging the
quantum of punishment.
disciplinary and the quantum of punishment. That's all.
Quantum of punishment, but when my learned friend has raised this issue, the Noble Kishore Sharma's case is very much clear. When bundle of facts are there, I think in such type of cases, well, regarding jurisdiction and
That's
maintainability,
what we are asking, which part of the bundle of facts are you here? Relating to the challenge that you are making now.
I am going to feel that is at the time when I filled up for that post, some date of birth was which was basically here. So it was here, then it was found false. Correct or false, that is another matter. But something happened here. So this court has jurisdiction. The Noble Kishore Sharma says like this. And well, my another submission would be that in such type of jurisdiction or maintainability matter, court should be very slow in dealing this type of matter strictly. Because here is everything is for the
No,
answer.
it is the other way around, because you are asking us or other jurisdiction your prayer by issuing an order in respect of an authority which is outside the territorial jurisdiction.
But my learned friend has said, shown the Kerala High Court's full bench judgment. But High Court's full bench judgment, I think the Supreme Court's judgment will always prevail.
No doubt on that, provided it is on the same issues.
No, I am on ratio, man.
So the ratio has to be on the facts which are right. Which paragraph you are referring to, Nawal Kishore again?
Yes, Noble Kishore's. Kindly see page para 9. Para 9. Here, power of 226 has been discussed, and later on, it has been held by the Honorable Supreme Court. On a plain reading of the amended provisions in clause 2, it is clear that now the High Court can issue a writ when the person or the authority against whom the writ is issued, here respondents are the authority, is located outside its territorial jurisdiction if the cause of action wholly or partially arises within the court's territorial jurisdiction. Cause of action for the purpose of Article 226(2) of the Constitution for all intent and purpose must be assigned the same meaning as envisaged under Section 20C of Code of Civil. So here,
No quarrel on that. Yes, same meaning must be ascribed.
the expression cause of action has not been defined in either the Code of Civil Procedure or the Constitution. Cause of action is bundle of facts, which is necessary for the plaintiff to prove in the suit before he can succeed. The term cause of action as appearing in clause 2 came up for consideration time and again before this court. So that was all discussed.
Is it one of your arguments that the document relied on by the authorities, which is travel from Gauhati, is not a correct document, or the interpretation of the document was
Correct.
incorrect.
No, I am not on that at this stage. At this is only something has happened here at Gauhati. And at first I was posted at Gauhati.
No, something has happened, no doubt. Many things have happened. Why something? But in so far as this proceeding is concerned, how is it relevant? For the purposes of the challenge you have made. You are simply challenging the dismissal order.
And kindly see, para 10, sub para 8, sub para 8, the expression cause of action is thusly defined in Mullah's case, Mullah's Code of Civil Procedure. The cause of action means every fact which if reversed.
Where are you reading?
Novel Kishore's para 10, sub para 8. The expression cause of action is thusly defined in Mullah's Code of Civil Procedure. The cause of action means every fact, which if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, it is a bundle of facts which taken with the law applicable to them gives the plaintiff a right to relief against defendant. The mere service of notice under section so and so, that is different thing, but the spirit is the same. The Honorable Supreme Court has said in bundle of facts means section 20 is also applicable in respect of writ petition, that is para 9, where the power of 226 has been discussed. Kindly see again para 9. The interpretation given by this court in the aforesaid decision resulted in undue hardship. So, the intention, Lordship would see, the intention of the Honorable Supreme Court was what? Undue hardship and inconvenience to the citizens to invoke writ jurisdiction.
Therefore, we are repeatedly asking you, is there any material that like come to a conclusion that your age at the time of filling
Was not
was
correct.
not correct. That interpretation is wrong. They relied on the right document, but
The wrong
it is contrary, wrong interpretation. Is there anything on the court to say?
No, I have said here, my lord, that hurriedly they have sent the report, and that's why they did not apply their mind that I have mentioned in my report.
On what basis are you saying this? That means you are saying the correct.
Not correct.
But on what materials to support?
Here, base, you may kindly see para 9 of my writ petition. Said that the imprisonment punishment provided by the commandant and upheld by the DIG are the result of non-application of mind, and also without considering his past extraordinary and excellences. The authorities could have provided any other punishment that is there. Then Lordship kindly say it has also touched the conscience and mind of any prudent person. So that is there, and
That is with regard to punishment.
yes. And see page 6, para 6. The petition of excuse said that finally the commandant was dissatisfied with the petitioner and accepted the inquiry report and dismissed the petitioner from his service by letter dated so and so. It was further stated in the dismissal order that the petitioner has the right to prepare an appeal. So that has been done. But I have trust. Some other things are also there. I think it is by not page 9, para 10. Here, petitioner expresses that the implement order of removal from service and rejection of appeal by the first appellate authority is highly illegal, arbitrary, unjust, and it has failed to consider his valuable service rendered by the petitioner to the nation for 19 years. The excellent service career. All this have been ignored and not considered by the government and the first appellate authority. I have no chance to explain my position in a befitting manner. So my whole submission is this, my lord. There are sufficient force in respect to maintainability of the case by the Honorable High Court. Now, my learned friend has shown one thing, that one order of this High Court that no appeal was filed, but that is not a ground. When there is order of Supreme Court, bundle of facts, any one of the facts is enough to entertain the request. Now, regarding relief, whether relief will be provided or not, that is another thing, but it is maintainable. Otherwise, it will bring untold hardship to the petition. He cannot go to Lucknow to file case and communicate with his lawyer, and more particularly when he is no longer in job. So, undue hardship word is used by the Honorable Supreme Court.
Which paragraph?
Yeah.
Which paragraph?
Yes. There are 9 men of Novel Kishore Sharma's case. The interpretation given by this court in the aforesaid decision, that means High Court has given some decision that the court has no jurisdiction when the cause of action arises in other High Court jurisdiction. Here, the Honorable Supreme Court says that the interpretation given by this court in the aforesaid decision resulted in undue hardship and inconvenience to the citizens to invoke this jurisdiction. As a result, clause 1A was inserted in Article 26 by the Constitution 15th Amendment Act 1963 and subsequently renumbered as clause 2 by the Constitution 42nd Amendment Act 1976. The amended clause 2 now reads as under: power of High Court to issue certain writs. Here, said that notwithstanding anything in Article 32, every High Court, so not only 32 that is Supreme Court's jurisdiction, but High Court shall have the power throughout the territories in relation to which it exercises jurisdiction to issue any personal authority, including in an applicable case any government within those territories, directions, orders, or writs, including writs in the nature of habeas corpus mandamus. So it is there, when. And it is also said that the certiorari or any of them for the enforcement of any of the rights conferred by Part 3 and for any other purpose, the power conferred by Clause 1 to issue directions, orders, or writs to any government authority or person may also be exercised by any High Court exercising jurisdiction in relation to territories within which the case of cause of action wholly or in part arises for the exercise of such power. So, my lord, my prayer is that it should be broadly discussed, leniently discussed. considering the words used by Honorable Supreme Court as well as intention of the legislation. And say this, accepting, then yes, I am on that. If my learned may insist on that, then I may be allowed to file additional petition.
After hearing,
No, actually, when we file equity, we never mentioned, lordship is never about this. That this court has jurisdiction,
Subit online.
this is implied. In normally lower civil court, when we file, then we have this court has jurisdiction to try this. But in high court, when we file,
Paragraph.
purpose, para 14 is also relevant. Para 14. In Om Prakash Srivastava versus Union of India, answering a similar question, this court observed that on a plain reading of clause 2 of Article 226, it is manifestly clear that the High Court can exercise power to issue direction, order, or writs for the enforcement of any of the fundamental rights or for any other purpose if the cause of action in relation to which it exercises jurisdiction, notwithstanding that the seat of the government or authority or the residence of a person against whom the direction or order writ is issued is not within the said territory. So that is also there. The question whether or not cause of action wholly or in part for filing a writ petition has arisen within the territorial limits of the High Court has to be decided in the light of the nature and character of the proceedings under Article 6 of the Constitution. In order to maintain a writ petitioner has to establish that a legal right claimed by him has prima facie either been infringed or is threatened to be infringed by the respondent within the territorial limits of the court's jurisdiction, and such infringement may take place by causing him actual injury or threat thereof. So, here also that part of cause of action. Now, whether part of cause of action has occurred here or not, well, that is up to your lordship. But in such types of matters, the court should take a lenient view so that party may hesitate their grievances at their doorstep. That is my humble submission. Right.
Counsel for parties. Their arguments before. No, this court. Power and that. But facts of the present petition is concerned.
I have got one citation. Just now I have come in my mind. It is a continuous injury. Continuous injury when a person from Lucknow to Assam, the continuous injury this person is suffering. So, Honorable Supreme said continuing injury should be dealt with a very reliant way.
Very, what judgment?
Because that's now I have remembered. Continuing injury. Because I am out of job from that day till today. So, if injury is continuous.
We'll have it on 33 March. The judgment, whatever you have, you
Yes, ma'am.
furnish to the
Yes.
court master today. All right, by tomorrow.
Don't worry, yes. Right.
By tomorrow. By tomorrow. It's 1:30.
All right.
I think what
SLP. The judgment. You submitted some judgment.
Two judgments are given, another judgment was 2026 SCC online.
No, 2020.
That is
13.
Andhra Pradesh based on Supreme Court judgment.
No,
It says tendency of the appeal is not a.
no, this is Lieutenant Commander who has submitted this.
They are given.
What proposition?
What is the proposition that the judgment of the court, not the judgment to was not state, and it doesn't give the license to the officials to disobey the order.
Which paragraph?
Paragraph 6, this Andhra Pradesh case which I have given, that is 101, paragraph 100.
No, we are asking you, there is a Supreme Court judgment submitted to the court master, 2020-13 SCC, page 1. It is submitted in your
Yes,
matters.
that is relied on court, paragraph 101. The judgment of the Delhi High Court, not the judgment of the AFT was state. The pendency of this appeal, the government should not have proceeded on exclusive basis that mere pendency of the present appeal was a license to not comply with the order. There is another judgment I have referred to, about paragraph 3. That paragraph was relied on while convicting the officers in the. But this is the more relevant 26, 2026 STP online Supreme Court.
When was the SLP, when was the division bench judgment delivered?
August 26, August 25.
25. And you have filed the SLP today. Seven 1/26. Yes. One and two, there is debited office. There is debited office. Right, but the question is why the order has not been complied. You show us one judgment that pending filing. Complied with. It's required to be complied with. Unless it stays suspended, aside, that steps are already being taken and an appeal has been filed. What is willful violation? There are 10. Judgment was delivered, you went in appeal. Appeal is dismissed in when? August 25. From August till today, or yesterday till you filed the SLP, there was no explanation why the order was not complied. Save and accept that you are trying to pursue a higher level. Has to file the evidence. Get instructions from the person concerned why this order has not been complied with. That is, you are competent to advise him that you are facing contempt. That you have gone and filed an appeal and the earlier person is not there. So the person who is now there, as on date, the order is still not complied with. He is required to comply with it. Tell us what is willful and what is not willful. What is not willful has been defined. That, yes, para 12 we are going there. Willful act is to be distinguished from an act done carelessly, thoughtlessly, heedlessly, inadvertently. Exactly. So where is the mistake? Where is that mistake? Come and explain it. That's what he's asking you to do. Where is that explanation? There is no bella fide. There was no we could not implement because of we do not understand how the order is to be applied. The person who had debited office, has he filed an affidavit? Why not? Did he debit office? When did he debit office? Is it not a sequel? It is not a consequential question. When did the person debit office? It not have been mentioned here that he debited office on so and so. Yes, Mr. Das,
For a moment.
are you intending to array the person who's arrayed, who succeeded?
Justice service on 29/11/20.
That's right, but we
So
don't know.
respondent number 1 and 2, they violated the order of the court.
That's right, but that is what we want to know. The day when you serve the dusty office,
Yes.
that is on 29/11,
They were there.
was this person there?
Yes. Respondent number 1 and 2. But I'll just read one paragraph. My lord, how the judgment they are given. 2026 SCP online. They with the
Where is this person? When did he debit office?
they have filed a my lord, they have accepted our thing in the month of November 20.
Then the affidavit will only explain what has happened subsequent to he taking over the office. The other incumbent has to explain why the order was not complied with.
There,
Has he filed an affidavit?
nothing else.
Then why is he not filed an? You are representing him. We had given you opportunity today in the second half. Your submission before the court was that once a matter is pending, there are judgments to show that contempt petition ought not to be dealt with. No, that is in the second half. In the first half, your submission was that once a petition is filed, then ordinarily the court should be little lenient and defer the contempt, for which we permitted you to show as a judgment. Now the judgments which you are showing are on the extent that they are on the aspect of willful, deliberate, and what is not willful, etc. In order to accept your submissions, the factual aspect will have to be placed before the court, namely whether the notice was served on the respondent one, whether on the day the dusty service was undertaken and received in the office of respondent one, when did he demit office?
I just take your lordship two paragraph of 26 Supreme Court.
No, all right. But the respondent is technically not represented. We do not know whether on the date
Represented by one advocate, but we
No,
have
he-
filed dusty
he is not-
service.
he is not holding power.
The dusty service was accepted on 29.
Can you tell us whether on that day the person was in
He was-
office? What is it? When did he demit office?
Filed the dusty, my lord, filed an affidavit
It was
showing serving
received,
of the copy.
received in the office.
Yes.
Which office is being manned by a successor today? The
That is
question is
there.
whether the gentleman at respondent one, was he holding office on that day?
To my knowledge, you are holding no. They are also unable to say. Because the council represented them, and the one council represented. Still, not. On the point is on the pendency of the appeal that the contempt will not proceed. That Supreme Court came heavily that you have taken that plea that the review petition is pending, appeal petition is pending, those are not to be taken into consideration. There is a stay. Court judgment is there provided. Let them file appeal law, let them appear before the court. The next day, because justice service, we have provided, my lord, that the case is going, that we have.
You inform us when did the earlier person debit office. Otherwise, we'll be constrained to call the person who is in charge now. Want you to inform us whether
29/11, 29/11, 20. But order to court.
where is the custody you have undertaken?
The justice is given on filed on 10/12/25. There are two, we have stated.
29/11/25. Please note the date. Custody was served on 29/11/25 in the office of the Secretary ART PPG. Whether the person at respondent number 1 was holding office on that date. Whatever. Yes, sir, received in the same office, in the office of the Secretary.
Box is recorded.
Yes.
Court earlier, court says that this, the letter itself is a contract. Letter.
Reference earlier ordered 10/3/2026. Submits that the last date. Wrong communication. Creative petition is filed by the state. If they go the apex court, however, stands corrected and SLP, which has been filed by the state on 12/3/26. Diary number 517/2026. Listed before the court. Therefore, submit that till SLP. Till after some order, any order is passed in the SLP. Mr. Nath submitted that several judgments that effect that when matters are pending in court, submission is made. Submission is still session. excellent session when the matter was called up. Mr. Nath submits that such judgment has no access to any such judgment as on date. However, from the ethics code, 16 SCC 204, in 3 SCC 705, and 6 SCC 332. That important proceeding decide whether the violation alleged by the violation of whether the alleged non-compliance necessary have been responded 1 and 2 served with 1911 516 served notice were returned back. Still notes embassy left RPS and the card or answer notice respondent. Card or answer notice. December 2025. as per the amendment made in the direction. I witnessed, which have been deliberate. Yeah, Mr. Nag, by written instruction. Same is currently being held by such circumstances. So, is currently held by the successor officer as to the date which the predecessor officer, namely Shantanu Bhuttacharya, steps are being taken by the successor officer compliance of the directions contained in the order dated so and so past. This matter again. First of April.
We also need a party.
It's for you to decide whether you want to make him a party.
Between the court and the order passed here.
No,
I'll pass.
therefore we have asked for the instructions as to whether what steps have been taken.
I'm also relying.
Mr. D.D. Das. Submit the dependency of past in the order of the past 640. Council was also referred to the Andhra Pradesh.
This is 122. STP online, Supreme Court 322. That says, my lord, the tendency of review and appeal, they are
That
adopting
is
the order of the
Supreme Court
court.
judgment.
Yes. 2026 STC online.
Then then since SCC online, SC. Yes. Higher appeal court. Inappropriate contempt. On 1st of April.
Starting in the government.
Huh? We will pass this order.
Yes.
Of course, name will be, we are conscious of that.
Yes.
Yes.
And some similar cases are here.
Yes.
I will mention those cases
Uh,
and the similar order will be passed.
we don't know. See, we will see when the matters are listed.
When it is. Okay. Observe yourself. One of my classmates, I did not know that he was here. Maninaka Sharma was my classmate. And he had been here in this case. Had I been known to me, I would have rang him at morning time. I did not know. Okay.
Them rang him, that's all right. But beyond that, we don't want to know why would you have wanted to ring him when your matters are fixed today.
Matter relates to rejection of the petition in the INE.
Where are Devi? Where is our Devi? Sir, factually. Factually not similar. You are found to be having some condition which may training or something may drive you in excavate, it may aggravate your medical condition.
Further, in the guidelines which has been prescribed lordship, as per the guidelines also, page 154 lordship, point number 5 lordship. Case of tuberculosis, cases of treated tuberculosis along with normal pulmonary function will be accepted as fit lordship. Guidelines.
What you saying that because of this calcified granuloma, the suggestion of a cold infection. Size is also larger. Current CPC, please tell us, if there is no history of the disease, then on what basis is the finding given that they be reactivated during an intense training? But there has to be a test done to confirm that. Have you done any test before civil hospitals?
Pulmonary test from Gauhati. 112.
Where is that?
Page 107, Lordship, Annex 12. The opinion of the doctor is in page 106. Next copy is at page 105, Lordship. Patient can undergo day-to-day activity as per PSP pulmonary function test held on 9/12/25.
The activity and this kind of training are different. Finding that you are fit for being inducted into service. Latent infection is that anybody can do day-to-day activity. Lying home, lying home. There will be rigorous training. put up by the forces. 104.
Tested himself in Fakultin alia medical college. After he was referred to. I am no history of TV life.
Annexure 10. Annexure 10 is finding put up by the respondent.
Our document.
Immediately relying on only says day to day. Not sufficient. There are conflicting medical report.
Guidelines. They have the review medical board is to obtain opinion from the concerned specialist or super specialist.
That's right. That's what we are referring to in page 104. This was perhaps
Was not by the respondent person. It is our document. Once we had privately diagnosed from a private center,
So 104.
had approached the Fakhruddin Ali Ahmed Medical College. The report at page 103 third.
what was the finding there?
And thereafter they have referred
the
us to
finding?
Gauhati Medical College.
Finding
No significant abnormality. Page number 103.
what?
They have not made comments also.
So they have
Yes,
suggested some treatment.
They have
Some treatment is there. See,
pulmonary consultation
where have you done that?
in GMCH bloodshed. That is at page 106.
1/6, it says you can undertake day-to-day activity. Come to page number 106, there is some advice here.
But that
CT after 6 months, have you done that?
it is member lordship after left upper lesion too small to undergo biopsy.
Who is not competent to decide on these medical issues unless you tell us that
Lordship, may I draw your attention? Page 111. Lordship. Number D, Lordship. Review medical board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt.
there is no
Therefore,
doubt.
Therefore, in cases of rejection, review medical examination medical findings should be corroborated with confirmatory test, investigation, opinion of specialists, super specialists of government hospital, medical colleges, government approved private medical centers, whichever and wherever applicable. They have to give an opinion of the super specialist of a government medical college.
Where is the RME?
Page 100, Lordship, that would be at 98.
HRTC was done.
Pulmonary specialist opinion was not there.
Some material to show that mere intense training will not be effective.
For that, Lordship, I am praying for re-examination.
Re-examination will send you only when we have some material. Say that the finding by the RME appears to be merely asking, we can't do it. There are Supreme Court judges who say that the RME done final. So that the RME did not undertake as mandated. Then tests are being done, you are found to be suitable to undergo intense training, then we can send you. That's it.
For the guidelines, Lordship, for declaring the unfit, Lordship, they have to obtain opinion
Only if
of
they're in doubt.
specialist.
Only if they're in doubt. Only if they're in doubt.
Lordship, and they have certain.
And clinical, see, before rejection, clinical findings should be corroborated. Test, opinion of specialist. Has any findings of the specialist been taken note of in the RME? Specialist of what? Down. Objection. Have to be given. Objection. That will find the word. C5 granuloma. Training that is the rejection. Find slash investigation slash opinion of special slash external opinion. Taken into consideration. That necessary to determine whether that he does not have. Necessary orders.
Kindly agree. Departmental.
What is council submit that since the termination, dismissal from service pursuant to inquiry, departmental proceeding. Say the matter would require the decision of the court. Why don't you try? That's all right, but why don't you go and try before the mediator?
I can try, but the bank, whether this is against the bank, so who will come and take the responsibility?
Therefore, since the pleadings are complete, matter be listed for hearing. The month
So-
of
That may be given to Allah.
May,
Why can't this 2000 he was, madam, he's
April.
going to retire.
April, the part two hearing list, April. Let it be in part two. Let it be in part two. Make a mention in court, we'll upgrade it.
If you.
That's the court. Mediation,
But if things have not yet been accessed,
so go for mediation. Try mediation. You may try and see if it can be resolved through mediation.
yes, sir.
The counsel for the parties are agreed that an attempt should be made to resolve the matter through mediation. Therefore, the parties will appear 27 March. 27 March.
Can it be made time bound, my lord? Within this period, it should be resolved.
First, you have to appear before the mediation. Can fix the time limit there. We can only fix a date for you to appear in the mediation, before the mediation. 27th of March.
The appearance on it is kept pending. They have
No, it will not be kept pending. In case anything like that happens, you can apprise the registry.
My lord.
Mediation, in which department? APTCL. Dismissal from service. What? Stoppage of one annual income. Right.
Your Lordship, since this is departmental proceeding,
Not to go for mediation.
yes.
See,
Can be fixed for a admission hearing next week or next week.
that we cannot guarantee you, but we'll if the petitioner be aggrieved if the matter is resolved through mediation. It may not be. Make an attempt.
But yes,
Make an attempt. If it doesn't work, you are coming back to the court again.
actually, Your Lordship, since it has been so many years, so just want to
You filed an appeal against the order of
yes,
imposition,
yes,
rejected.
rejected.
Parties to the counsel for the parties submit that this matter pertains to a departmental proceeding in the court.
Your Lordship, interim order continues.
Therefore, matter will require hearing. Readings are complete.
Yes, but for
Let the respondents file complete their instructions and file affidavit if so advised. List again after 3 weeks. Interim order, as earlier, will continue, if any. On 10th of April. 10th of April. Mediation. Counsel for the petitioner submits the mediation. On 27th of March.
My client is conceding for mediation, my lord. Because as per master circular or railway, my lord, a fresh chance can be given to him for
Very well. Why is he come before the court now?
after that, they have
Hmm.
Yes, I don't know, my lord. My client, I have annexed the care order, my lord.
So then we can't refer it.
And
The counsel for the party, for the respondent submits that there are material facts which have not been stated by the petitioner before approaching this court. But facts would be necessary to decide. Decision. After 3 weeks.
So Roy has to go.
Right?
Otherwise, not a very short issue. I'm covered. I was dismissed from service, and then I was reinstated with all consequential benefits, man. So, invoking rule FR 54A3, my lord, I'm entitled, man. That's just my humble prayer.
54
A3.
E3. That's 54A3 say.
If the dismissal, removal, or compulsory retirement of a government servant is set aside by the court on merits of the case, on merits of the case, period intervening between the date of dismissal, removal, or compulsory retirement, as the case may be, and the date of reinstatement shall be treated as duty for all purposes, and he shall be paid the full pay and the allowances for the period to which he would have been entitled had he not been dismissed, removed, or compulsory retired, or suspended prior to such dismissal, removal, or compulsory retirement, as the case may be. The judgment, Madam Dipali,
Gundu.
Kirpali. Simple, narrow compass of case. Though they invoke 54, Lordship will find the impugn order at page 32. C is not there.
Let's come back to the order. Where is the order?
Page 32, man, annexure 4 of the petition.
Yes.
At the bottom. 6 is the head para
Yes.
and sub. Hence, as direction of the court under so and so, so and so. I understand issue.
No, first, let us understand the direction of the court. What is the direction of the
Court, final court direction through. Not will find the direction of the court at page 23. It starts, my lord, ends at 28. The penultimate paragraph. It starts, however. No, not however, just about that matter. The respondents are now directed to forthwith reinstate the petitioners back in service along with all other consequential service benefits. However, liberty is granted to the respondents to conduct a fresh department proceeding if so advised in the event the respondents conduct a fresh department proceeding. It is made clear that the same should be completed within a period of so and so months. With such observations, the direction the repeated still disposal. Then, my lord, the union goes to the division bench at page 39, 29. Then union goes, well, union, the read appeal fails, my lord, at page 31. Para 6, if that be the position, when a position of law has been settled by the Honorable Supreme Court, the same would also apply to present text as well. In that be the position, we see no error committed by the learned single judge so as to call for interference of this appeal. Accordingly, this instant appeal being devoid of merit stands disposal. However, there was a rider at para 7. In view of the disposal of the appeal and having noticed the learned single judge has fixed a time frame for completion of proceeding to an extent, the time is now extended by 3 months from the date of this order, madam. One fact that will be very pertinent manner, though liberty was granted to the respondent authorities to proceed afresh, they proceeded, but there was a time frame to complete. That time frame was also violated by the respondents. Madam. The Lordship will find that in their affidavit in opposition, page 84. Appeal order is of 1/2/2019, and they order a fresh DP against me in the month of March 23/19 and concluded by 13 September 2019. If the test of the FR 54.5, if test is given, I have to undergo the test, but there is a.
But I'm referring to the judgment.
My lord.
That is what it says there. 38.3.
Here, man, I stand on a different footing because the learned single judge, while deciding my petition, while means reinstating me on service, has given that I am entitled to all consequential benefits. Slightly different footing.
Who the respondent?
Just Roy was there, man. He was the entrusted with this bill. I think this person is retiring on 30th of this month.
Heard Mr. D. Gogoi comes into the picture and represents the CBC. The challenge to the court stated
Ordered, my lords. It's 4 May 2019.
4th of May
4 May.
2019 by dismissal. Cancel. Order of the court.
You will find two orders at page
The single bench.
page 28, man. It's the petition order. Page 23, it starts. Order dated, my lords, 25/2016.
So the court had set aside the orders.
Set aside my lords, say the dismissal.
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 Then liberty was granted.
Liberty was granted. Then
Then
union was
why at page number 32, why is there a reference that order of dismissal is hereby cancelled?
because, my lords, we had pressed a contempt petition, and though the court had interfered, formally they didn't issue any comment.
Subsequently, there was no proceeding initiated.
There was initiated. That was initiated.
Then what happened?
My lord, that they lordship will find that writ appeal order, they were given a time frame of 3 months. They initiated it in the month of lordship, page 77 of the affidavit of opposition, in the month of March 23, 2019. Writ appeal order is of 1/2/2019.
77.
77. There's a SD signature to 23/2019. This said admin NES. Interestingly, with the old memo of charges. Okay? I'm not into that now, my lord. Now, lordship, that proceeding culminates in the month of September. Lordship will find at page 84.
Cancelled. interrupted period from 31/5/2004. Treated as period not spent on duty as per Fundamental Rules 54, and that they will be paid 50%, and that she will be paid 50%. He or she,
He meant.
he,
Not
he
Dr.
will be,
Kohli.
he will be paid 50% of pay and allowances for the said period. But the said period, however, will be counted for the purposes of seniority as per FR 54 within bracket 5. Stop. Although petitioner has submitted non-engagement certificate for the said period, back wages and other benefits were not being agreed. Suppose that the FR 54 capital D, capital D3 must provide that if the dismissal, removal, or compulsory retirement of the government servant is set aside by the court, and its period pending between the date of dismissal or removal, retirement, suspension, preceding such a period, and the date of reinstatement shall be treated as duty for all purposes, and he shall be paid full pay and allowances for the period which he would have been entitled